start. So welcome everybody who's joined the call. I'm John Whelan from CRF, one of the directors with CRF, and I co-chair our ER-IR network with my colleague Nick Dalton. Nick can't join us today. He's enjoying the sunshine in South Africa, so that's nice for him. We're enjoying the rain, which doesn't seem to want to stop. So we will have today, you will hear from my colleague Melissa Ball. Melissa is our commercial director at CRF, and she's going to talk to you in a moment about the network. And then we'll hear from Clare Ward. Clare is Labour Relations Partner at Eversheds Sutherland, and Clare's going to give us an update and status on the Employment Rights Act, which is, Clare was just saying, changing by the minute, by the day. So it's a kind of fluid, moving picture. And then we'll hear from Kevin Rowan, who's the Director of Dispute Resolution at Acas, who will talk to us a little bit about what Acas are observing and perhaps some advice to employers around that. We would ask you to, I hope we've got quite a big audience. I can't see the numbers on my screen, but I would ask you to post your comments or your questions rather in the chat, so we'll be able to see them there, and we'll be able to monitor them and either interject them as people talk, or probably after Clare and Kevin have spoken, we'll start to take your questions. If I can encourage you not to perhaps go to the most nitty-gritty of questions, because there are other ways you can find out those answers, but rather, you know, the more thematic things or the more sort of policy level things, etc. But I don't want to put you off asking questions, but just, you know, details on specific dates and numbers, etc. We can provide another way. We will share with you the slides that we're going to show that Clare and Kevin are going to use. And we will share with you a report that I'm going to just briefly mention in a moment. That's one of our first outputs from the ER network, a research report, as well as a link to our ER-IR network website, because we do have lots of people on the call who are already members of our network, but there may be others who wish to find out more and to join. So we'll share a link to the landing page of that site. So why did we set up the network? Well, we set it up over a year ago now because we realized that things were changing, things were happening in this space, not least the Employment Rights Bill, which became the Employment Rights Act recently, but also perhaps changes in workplace practices, changes in the way people interact with employers and employers interact with people, the influence of social media on that and networks. So, you know, we could see there was sort of change in the air, and we were conscious that, you know, ER and IR had slightly got out of fashion unless you're in one of the big sort of industrial companies or big unionized companies. But it was very much coming back with a bang. And companies that may have never considered themselves to be unionized environments may now be approached by unions to say, we'd like to organize in your workplace. Or there were other forms of kind of collective voice that were evolving in the companies. So we decided to set it up, and also to think about how could we develop a new generation maybe of ER-IR practitioners who deal with today's issues. So we put together a package around that which is an addition to our CRF offering. Mel, could you just tell us, you know, what's in that package and why people should want to join us in this network?
Yeah, absolutely.
Right.
We've got a really packed agenda for the year ahead. So as John mentioned, the reason that we run this network is to gather senior employee relations colleagues together to learn from each other, to share experiences, and to rely on the collective wisdom of the group. We also have input from our legal partner Eversheds and people like Kevin at Acas. So you know, there is also an expert view that we bring to that. Nick Dalton and John Whelan, who have a wealth of experience between them, bring they write our research. Topics for next year include things like implementing the Employment Rights Act, They include things like social media and going viral. They include things like AI and case management and the nightmare that has become for some. And it's about finding solutions to some of these challenges and opportunities. As part of the network, you get access to places at these events, at the dinners, at the full day events, at the breakfasts. You get access to all the research. You get a place on our learning program that helps to design a win-win employee relations strategy. And there's plenty of other benefits as well. And if you get discounts as well if you're already an existing CRF member. So if you're not a member of the network yet and you'd like to be, I'd love to chat to you. I'll make sure my details are in the chat and let's connect.
Brilliant. Thanks, Mel. Yeah, it's quite a package. So one of the elements is research, as Mel has mentioned. We've completed 2 or 3 pieces of research already. We did a really interesting piece on employee resource groups, which talks about how those employee voice type groups were changing and evolving. That's available. But we did a bigger piece on the Employment Rights Act, just as it was kind of becoming an act, if you like, mainly authored by Nick, our colleague, with inputs from others. And just want to give you a brief flavour of it before we dive into the act a little bit more. And what we said in that report was we were picking up from our colleagues and our members and our network that people were taking roughly 4 approaches. Now, these are a bit stylized. They weren't exactly what people were doing, but we were seeing sort of 4 approaches to the new legislation. The first one we called minimize impact. Those who kind of thought they'd try and ignore it and see if it went away, or downplay the impacts of it and kind of try and carry on business as usual. Well, you can't exactly carry on with business as usual, but it's more of an attitude towards the legislation, if you like. There's certain things that obviously you'll be compelled to do. But there were those who thought, we just need to sort of minimize the impact of this on our business. The second group, which was a sort of bigger and probably the majority of organisations, were probably thinking about minimising the risks. They knew they had to do something and they had to ensure compliance with the new legislation, which is not trivial. I think Claire and Kevin would agree. There's quite a lot to do just to be compliant. Those people were, they wanted to be compliant and to do all the right things, etc., and not get themselves in a difficult position with anybody. The third group, probably the second most common group, was to those who felt they could optimize the value of it, adopting a more strategic approach to it, to say, let's embrace this bill and what it means, and how do we respond in a sort of slightly more strategic way? Does that mean we have to change relationships with people or deal with people in a different way? And the last group, I'm rushing through it, but you can read it at your leisure. We'll put a link somewhere. The last group we said Nick called them, said they were revolutionizing the paradigm, which is a nice little phrase. Those who said this is an opportunity for us to really rethink the relationship we have with our people and how we manage that and do things completely different off the back of the new act. We don't say that was many people, but there were some who just used it as an opportunity to rethink and relaunch, perhaps in a more strategic or positive way. So have a read of that. It goes into the detail of the act, of course, and the specific and the background to the act and why we got where we were and the sort of evolution of ER, and then has a sort of more of a strategic overview, if you like. I'm going to turn to Claire. I've only got 1 hour, and if I keep rabbiting, we will use it all up. I'm going to turn to Claire and say, Claire, it's a tricky one because, as you say, it's changing all the time, but perhaps you could give us a status of where we are on the Act and what we should be thinking about at the moment.
Absolutely. Have the slides have come up there?
Yeah.
Have they? Okay. Yeah.
Yeah.
So just going to try and give you a flavour. I've just been asked to keep this to around about 10 minutes. So we are going to send you a copy of these slides. So just by way of introduction, my name's Clare Ward. I'm a partner with Eversheds Sutherland. I am an employment lawyer by trade, but I spend the vast majority of my time helping employers navigate their collective rights landscape. So trade unions and other collective matters. I've popped my QR code on there where you can link with me on LinkedIn. So I would welcome you to be new connections. So diving in, how did this bill become an act? So it gained royal assent on the 18th of December. And just before royal assent, there were two last minute amendments that broke the sort of deadlock as it was ping-ponging between the House of Lords and the Commons. So two really key changes that happened right at the last moment. And I'm going to return to those, but that was the doing away of this sort of idea of day one rights for unfair dismissal and reducing the existing 2-year service requirement to 6 months, and a rather unexpected removal of the unfair dismissal compensation cap. The government recommitted to its roadmap timelines, which it had published, which sets out the series of anticipated dates across April 2026, October 26, and then into 2027. Yesterday, though, there was an announcement that a number of those were being amended, and I will mention those as I go through. I'm going to update these slides before we send them round to you, so you've got the updated information on there. There's more on here than I will go through today, but you will get them as a reference. So as we transition from royal assent into implementation, you will see a raft of further consultations. I received notice about half an hour ago that a further consultation has been issued, and anyone can input into those. It's quite simple. You can do it online via the government website. So we'll also see then resulting draft regulations, new and updated codes of practice, both from the government and Acas guidance that we're expecting. So some of these changes require transitional provisions, so therefore the things that may have events that straddle the commencement dates, and we are still awaiting the Equality, Race and Disability Bill, which will look at extending pay gap reporting and extending equal pay rights. So I think it's useful to put these changes into 4 buckets, if you like. So to start with, we've got unfair dismissal. The 2-year qualifying period is reducing to 6 months. Now, this will be from the 1st of January 2027, but it's really crucial that everybody understands that that is for people that have 6 months service from that date. So essentially, anyone that you are recruiting from the 1st of July, you would have a 6-month service requirement, not 2 years. And given notice periods and recruitment processes, what that means is people that you are recruiting now, you would be gaining their service rights most likely after 6 months. So in terms of what that means for employers, probationary periods and managers actually managing those probationary periods. We often see probationary periods of 6 months. That will be too long in the new world, because although we talk about 2 years and now 6 months, what's important to remember is that you effectively gain your rights a week ahead of that, because you have to add your statutory notice period. So if you're dealing with terminating probation at 6 months, it's too late. You've already got your unfair dismissal rights and therefore those risks. The other key change that I just wanted to flag was around the removal of the unfair dismissal cap. This was thrown in at the 11th hour and will make a significant difference for the risk profile of dismissing any high earners. Till now, you knew that the cap was the lower of a year's salary, or around about £118,000. Going forward, there's no parameters. So entering into settlement agreements, etc., will take on a whole new life in terms of negotiations there. So really significant change. Also, just on redundancy, the immediate change, or the more immediate change, is the doubling of the proactive or protective award to 180 days gross pay per employee with effect from the 6th of April. So really needing to make sure those redundancy consultation processes are done really well, because your liability will double. The changes in the establishment threshold will come later, 2027, and there'll be further consultations around how that new threshold will work. Fire and rehire is essentially being outlawed in respect of restricted variations, and that's all of the useful stuff, by the way: pay, hours, time off, shifts, pensions, unless you can show that your organisation is essentially in financial distress. We thought that was going to be in October, but the government announced yesterday that that would be delayed, and it looks like till January 2027. In terms of diversity and family friendly changes, the immediate changes are the inclusion of sexual harassment allegations as amounting to whistleblowing, day one rights for paternity and unpaid parental leave, and the removal of the lower earnings threshold and the 3-day waiting period for SSP. They're all going to be upon you in April, with further changes coming in October. Probably the most significant is the change from the proactive duty to prevent sexual harassment, moving to all reasonable steps rather than just reasonable steps. So revisiting your activities there well in advance would be my recommendation. Third bucket then is around enforcement changes. It was confirmed yesterday that the dates for the establishment of the Fair Work Agency is going to be the 7th of April rather than the 6th of April. Not entirely sure of the reason for the move of that by one day. We've also been told that the changes to the time limits for tribunal claims, which is being increased from 3 months to 6 months, will be no earlier than October 2026. In respect of the Fair Work Agency, just thinking about where you're up to in terms of any national minimum wage compliance, making sure your SSP is all in place, your holiday pay compliance, and considering, I suppose, your risk strategy. Occasionally, employers do look at things like holiday pay on a risk-based, will anybody claim type approach, and you would want to be revisiting those types of strategies. In terms of the 0 and low hours, we're still awaiting a consultation, and the implementation for that is still planned in 2027. Just finally, in terms of my fourth bucket, this is my favourite subject, and it's the raft of changes around trade unions and worker voice. We have some of the industrial action changes coming in for ballots that open on or after the 18th of February. So really imminent in terms of for example, the reduction in the notice for industrial action going from 14 days to 10 days, the mandate extending from 6 months to 12 months, all imminent. The changes to the statutory recognition process would come in April, and we had a consultation that has literally just launched today around how that will look. And then really in terms of a whole new landscape is the introduction of the right to request and ultimately enforce access for trade unions. So in terms of preparation, although that one isn't due until October, my advice would be to really be thinking about your workplaces, your digital communication systems, what might a union seek access in respect of, and is that something that you can accommodate? What will be your response when you receive a request? Timeframes are going to be incredibly rapid, so you need to be thinking about that now. I've just rattled through 4 buckets of changes that amount to about 28 different employment law changes. So what I've put up there is a QR code where you can access our tracker. That is searchable by topic. So if you're thinking those slides said something about X, you'd be able to go to that and have a look at what's at the summary of what's coming up. It's also got searchable by date. So if you're thinking I really need to prioritize the April changes, you can go straight to those. And that's also got our briefings on there. So I'd encourage you to scan that code and save that to your favorites bar, because that's updated live along the way. I think I just about managed to get that all in the 10 minutes, John. So
Yeah, brilliant. Well, no, well done, Claire. I mean, it's impossible to cover that in 10 minutes. So much going on, but you've given the sort of categories that we should be thinking about. The tracker's there, and it's free and open to everyone, is it?
Absolutely. I will, in addition to that code that you'll get, I'll pop the link in the chat now.
Brilliant. So thanks so far. We're going to come back to you for some questions in a moment, but I'm going to turn to Kevin and say, Kevin, from an Acas point of view, what are you observing, and what would your sort of key pieces of advice be for specifically for employers in this discussion? Although, of course, you don't just deal with employers.
Yeah, thanks, John. Thanks, Claire, for that as well, and thanks for the invite to come along and join the conversation today. As slide says in your introduction, I'm the Director of Dispute Resolution at Acas. I've been there about 10 months now, and as you can probably pick up from the remarks we've heard earlier, this has been an incredibly busy time with all of the changes that are happening in workplaces and in the employment rights industrial relations field. I'm going to try and limit my comments to 10 minutes, but my role in Acas is to cover two operational functions, really. One is around supporting individual dispute resolution, and I'll talk a little bit about that in a second, but also collective dispute resolution, which is where kind of Claire's presentation and mine overlap a little bit, or at least hopefully there's a degree of synergy in terms of encouraging people to try and be prepared for what is undoubtedly the biggest change in the employment rights and industrial landscape for a generation, at least, possibly the biggest set of changes that anyone's ever witnessed. It is really voluminous and an awful lot for people to get to grips with. So I'm going to try and whiz through this in 10 minutes. There's not as much detail in my slides as there are in Claire's, but very happy to share them after the event if people want copies. So basically, I'm just going to kind of highlight a couple of trends, really, in terms of the talking about individual conflict first, individual dispute resolution first. We've seen something really quite radical happening in the last year or so. We would normally see a fairly level or very gentle increase in the kind of prevalence of individual disputes in workplaces coming through to Acas. But in the last 12 months, we've seen cases coming into Acas, and if people aren't familiar with it, if people want to pursue an employment tribunal, they get directed to Acas for early conciliation, and that's our individual caseload. In the last 12 months, we've seen an increase of 26% in the demand coming into Acas for early conciliation. That's as big an increase as we've ever seen. And in fact, in January, we look back at January last month, and we're averaging a little over 3,300 cases a week coming into Acas, which is the highest level of demand that we've ever seen in that. So, I mean, this is just phenomenal shock to the system, and it reflects, I think, something happening in the workplace that we don't quite understand yet. There's no real explanation for this increase, because this is ahead of some of the rights that Claire's just been talking about. It's ahead of changes to the unfair dismissal qualification period. It's all happening ahead of that. So there's something else going on in the workplace and in the employment rights field. Just to kind of add a little bit of context to it, because it's not just volume that's going up, the complexity of cases that are coming into Acas is changing too, the composition of cases. And this side, we call them open period cases, but effectively that's what that means is cases that have a discrimination element to them. And they're inevitably more complex than a straightforward wages issue or holiday pay issue or sick pay issue. These are cases that are more complex, more difficult to resolve for parties, but as well for Acas and other organisations trying to resolve those issues. And that trend shown an increase, a relative increase in the proportion of complex cases coming in, discrimination cases coming in of about 40% in that period. So not only are we getting a huge increase in volume, bigger than we've ever seen, but the complexity and difficulty of cases coming through the system is getting more difficult too. And I think I'm sure this reflects what's happening in workplaces. And there's no hard evidence to explain what the drivers of that demand are. We can speculate. Certainly, Acas published a report last year on prevalence of conflict in the workplace, and something like 50% of employees have identified that they've got an issue in the workplace, and that's again the highest number that we've ever seen in that conflict of prevalence report. Now, most of them just get resolved. They raise it with the manager, it gets resolved. But increasingly, people are taking those issues through formal processes, discipline, grievance, leading to other issues. One factor, and I think Clare or John mentioned this, a lot of those cases are informed by some kind of AI support. So workers, going on a ChatGPT or whatever, and what would be a kind of straightforward, I've got this concern at work, this is how we resolve it, is almost being inflated to a 30-page grievance that then becomes incredibly complicated. So there's certainly something in that AI world in terms of driving those cases. We also know things that happen in society increase demand. So when we saw the kind of Me Too movement or Black Lives Matter movement, we saw an increase in sexual harassment cases coming through or race cases coming through. This latest trend seems to be as much driven by disability claims as anything else, and particularly neurodiversity claims. Again, we haven't really got to the bottom of why that is, but there is an increased awareness among society of those issues. And certainly when I talk to employers, and I'd be keen to hear your experience, employers say to me that understanding what the right reasonable adjustment is more difficult if you don't have the depth of knowledge of the issues that are driving the claim. So that might be a factor too. And we certainly think that the legislative framework is contributing to an increase in discrimination-based claims as well, as Clare would confirm. There's no qualifying period for an unfair dismissal claim on discrimination. The compensation awards are bigger, and whether that through that kind of AI network or process is also informing the type of claims that are coming in and maybe a factor too. So that's what's happening in the individual space. I've absolutely whizzed through that. Happy to pick up any kind of further comments in the questions. Collectively, I'm going to touch wood as I say this. It's been a relatively quiet period for a year or so. We've seen peaks and troughs in collective disputes and industrial action. Most recently, spike caused by some of the kind of big national public sector disputes, but it's been a relatively quiet period. For the reasons that some of the reasons that Clare's outlined, we're anticipating it won't be quiet moving forward. We're expecting more turbulence in the collective space, and a number of reasons for that. Clearly, people be aware there is still lots of kind of sense that the cost of living challenges haven't gone away. People are still feeling the pinch. It's driving, kind of tensions around collective bargaining and pay negotiations. Certainly, over half the cases that we're dealing with are to do with pay. The second biggest issue is recognition agreements. I'll come back to that in a second. Relatively quiet, but there are still those underlying tensions that are driving some of the collective activity in workplace, and I'm sure Clare would reflect that in the work that Eversheds lead on as well. But we know that the changes that Clare outlined, and I won't go over them again, are very likely to stimulate more collective activity across the economy. Access to workplace regulations is something trade unions have been campaigning for a long time. I'm genuinely not sure how prepared unions are to kind of capitalise and utilise those regulations, but it will certainly stimulate a lot of activity in workplaces where unions don't currently have a footprint. You could argue, and I think it's reasonable to argue, that that's supported by changes to the statutory recognition processes and regulations. It's going to be easier for unions to access workplaces. It's going to be easier for them to kind of secure statutory recognition processes. And if things don't go the way unions want in those conversations, then there are changes to the industrial action and balloting regulations, which will make it easier for them to progress towards collective action. Now, it's very difficult to predict the impact of that in terms of volume or sector or what that, but the mood music and the environment in which this is happening is going to be loaded very much towards trade unions taking more collective activity in that space. So, that I just want to be very clear, and I think Clare was suggesting this in her presentation as well. This is going to pose some real challenges for employers who don't currently have arrangements with trade unions. So, to kind of answer the question in terms of, well, what advice would I give to employers? What advice would Acas give to employers? I think not ignoring what's happening in the individual dispute resolution space is important. That trend is likely to continue. So being prepared, if you like, to have the skills, knowledges and processes for tackling an increase in those individual issues and individual contact, and trying to kind of make sure that there are systems in place for resolving issues early in the workplace, getting ahead of the formal process is absolutely vital. We know that those individual disputes are costing employers well over £30 billion a year collectively. So there's a really strong case for getting ahead of those individual issues in the workplace, individual areas of conflict. But then in terms of trying to get ahead of the collective changes, if I was an employer, I'd be saying, start a conversation with your workforce now. And Clare was talking about, those individual communication issues. Start utilising them now, preparing them for what's coming, and taking the temperature of the workforce in terms of their enthusiasm or desires and aspirations for what collective arrangements might look like in the workplace. Not everybody wants to join a trade union, but most people do want a voice in the workplace. So thinking about what those arrangements might look like for you as an employer. I think we've seen this, and certainly the NIC's report that John referred to alludes to this as well. We've seen a reduction in collective bargaining skills, knowledges and processes. So upskilling in that space to try and be prepared for some of the collective bargaining challenges that are for sure going to come to a lot of workplaces in the next couple of years. And then think about being proactive in this space. The 4 buckets that NIC's report refers to, there are very different attitudes towards this. And I understand that and accept that. But there's an opportunity to be positive about this and to see this as an opportunity and a positive opportunity for employers. So think about reaching out to unions that you might want to work with. And there are lots of different personalities in the trade union movement. So be proactive about the kind of arrangements that you want in place and trying to get on the front foot of that, so employers aren't reacting to some of the challenges that the the changes in the legislative environment are going to provide. I'm going to stop there, John. Very happy to pick up any questions or comments that colleagues might have.
Brilliant. Thanks, Kevin. Yeah, and I think some of the last points there are about, good practices anyway, aren't they? Let's make sure we're trying to resolve things at source rather than letting them escalate, etc. I'm going to come back to one of those points, but Lauren just posted with, thank you, Claire, for answering some of the specific questions in the chat. But Lauren just posted, what do we think will be the most challenging aspect for employers who currently do recognise a TU? What do we think? Let's start with Kevin. What's going to vex us most, those who are already in the TU environment?
So I think that if you're already recognising trade unions, then you'll have and there are different types of relationships
And
for
it's the ER webinar, so
Mel, you're online.
Sorry.
Right.
Again, there are different challenges for depending on the type of relationship you've got with the type of union that you work with. But undoubtedly, changes to the industrial action balloting arrangements for employers that already have recognition arrangements will potentially impact on the nature of that relationship and the flavour of that relationship. And not all unions are the same. Let's be clear. There are some unions that are very driven by a kind of conflictual model of relationships with employers. There are others that see themselves more as a kind of social and economic partner. But I think the changes to if you've already got a relationship, I think the changes to the industrial action ballots are probably the ones that present the most concern.
Yeah. Claire, what do you think? And can we then broaden to what about companies who don't currently recognise TUs? Kevin's touched on that, but ask the first one first.
Yeah, so I suppose just to add to what Kevin's just said about those that do recognise trade unions, I know that a number of employers and sort of union contacts have said that they're concerned that the new right of access could increase the sort of inter-union competition. So you may have a union partner that you have a good relationship with, but you might get that doesn't bar requests for access from another union. The consultation suggests that it might be a factor, so therefore it's not ruled out. So a number of employers sort of suggesting that they're concerned that they could become embroiled in sort of inter-union competition. And I know some of the unions, particularly those that Kevin was sort of suggesting that see themselves more as a socio-economic type partner, are worried that those that are perhaps more combative or the newer sort of protest unions might be seeking to recruit their members and gain sort of access, and therefore they can't get statutory recognition but influence. And then in terms of those that don't recognise trade unions, I think it's just being aware that the landscape really has changed or is changing. And when you take all of these things as a package, taken together, means that it will be easier for unions to gain recognition with less clear support from those that would be covered by that recognition because of the changes to the recognition regime. And of course, because of the right to access, the profile of trade unions will potentially be increased because they'll have a more ability to recruit and raise their profile of what they offer. And then thirdly, because of all those other changes, we've tended not to focus a great deal on the new requirement to issue statements to employees of the right to join trade unions. But the requirement to do that for both new employees and existing employees on some sort of periodic basis will again just raise the profile in general. So for those employers that sort of haven't traditionally been unionized, haven't traditionally been the subject of recruitment campaigns, the the likelihood is that could well change, over the next few years.
Mm. We talked about one of the things you've mentioned along the way, Claire, is digital access, which is intriguing me a bit in terms of how's that going to work? How does that sit alongside data protection type considerations? How do you see it working? What are the provisions?
So what we know thus far is not a great deal, but the GDPR isn't going to be amended as a result of these provisions. So the Parliament has made clear that digital access will need to be introduced in a way that is compliant with the existing GDPR legislation. So what we anticipate is that the employer will need to be the vehicle to communicate what the unions are asking to be conveyed. So if, say, for example, you've got a digital app that you use to communicate with your employees, rather than the union actually having access or administrative rights to that app, what is more likely is that the employer would be required to disseminate the information via the app. In the explanatory notes to the Act, the one example that was given was the requirement to issue an all staff email. So not to grant the union access to your email system, but to disseminate that information. Now, of course, that may well, though, be different if what the unions are asking for is access for employees to do certain activities. So when we had the head of policy for Unison speak at our Labour Relations conference, what he was saying was that he anticipated that they would have a network of employees who would essentially act as representatives and would be potentially holding meetings or recruitment surveys. So where it comes to digital access, and it might be a bit more complex, as if somebody who already has access to your email system is then wanting to perhaps have, say, rights to send all staff emails. But all of this will be subject to code of practice and will come down to what you put in an access agreement. And if you can enter into an access agreement with the union without the input of the CAC, then that may be preferable because you would have greater control over these things.
Great, thank you. Just two questions really. There's a specific one on parental leave in the chat there. I'm going to leave Claire to have a think about that one. I don't even know what BPPL means, but I can see the sense in the question. The two things that come to mind. One is there is an opportunity for further consultation. So Kevin, how should people go about that? What's the most effective way to have your voice heard as an employer, do you think?
Well, so certainly there will be lots of more opportunities for consultations in the time ahead. I mean, as Claire was saying in her presentation, people can follow the government's kind of consultation route and put in individual responses to that. There's usually a kind of pro forma set of questions alongside the consultations. I always think that it's more powerful if employers try to do that collectively. So, the CRF would be one vehicle for doing that. And, I think the more people can collect those kind of shared issues, concerns, and ideas, because I think the government are still open to how do we make these changes land positively in the real world. So if people got positive ideas for that, then I think they'd be welcome. So there is both that route individually, but I say I would encourage some collective responses. I think we're past the stage of the government just thinking, well, I've had 65 consultations, therefore this. I think the more collectivized they are, the better, really.
Yeah. So trade bodies, industry bodies, etc.
Yeah, I think so.
Yeah. Yeah. And I think people should, if you don't know your trade and industry body, you should get involved and see what they're saying on your behalf, really. And Kevin, staying with you, you showed us that relatively alarming set of graphs around the rises in cases and the complexity of those cases. I'm kind of conscious that Acas is not a massive organisation with unlimited resources, so it'll put a strain on you, and and perhaps even more so the tribunals when things do end up in the tribunals. How are you and the tribunals going to cope with like an increase in demand, and we haven't even got the new provisions in place yet in total?
Yeah, it's a bit of a $6 million question for me at the minute, that one, John. Well, certainly we're looking at how we can improve productivity and efficiency within the individual dispute resolution service, and there are things that we can do. We have probably about 20% of the cases that come through shouldn't come through. They're either out of time, or they're not clear about the jurisdictions, or sometimes it's a self-employed person who hasn't been paid, and they end up coming through our route rather than the correct route. So we've got to make sure that we're filtering those out of the system better. We certainly think there are improvements we can make in terms of the conciliation process itself. We do try and bend over backwards to kind of respond to our service users. So we'll try ping pong between workers and employers, and to try and find a resolution. I think we've got to shorten that process and offer maybe a couple of appointments to both parties, and then move on. So there are productivity gains that we can make, and we've got to introduce lots more digital systems. Online dispute resolution for where parties are represented seems reasonable. That will take some out, but ultimately, I had this conversation with Minister Dearden last week. We've got to try and help employers, trade unions, and workers to resolve issues much earlier in the workplace. If we don't stem the tide of cases coming into formal procedures, and we're always going to be chasing our time. So a big focus on what early resolution looks like in the workplace, big challenges on that around culture, around skills and confidence and trust. But if we don't kind of start to tackle issues upstream in the workplace much earlier and much more informally, then the system is going to continue to creak really quite badly.
Yeah. And has there been any discussion about the tribunal system and whether changes that will be needed, or resources, or?
Yeah, I mean, I don't want to kind of breach any confidences, John, but I'm part of a dispute resolution system task force that's both set up by the Department for Business and the Ministry of Justice. And we are looking at some quite bold proposals to recommend to the ministers to bring forward, including, and I know Claire will be following this closely, but different tracks for different types of cases. So it's one size fits all at the minute, and there could be some quite straightforward cases that really shouldn't be going anywhere near a tribunal. Obviously, I think mentioned the Fair Work Agency, that's going to move to enforcing some of those cases that would occasionally progress to tribunal. So getting a lot of those fairly straightforward cases dealt with out of the system.
Yeah.
And then thinking about some different routes for more complex cases, including, I think, considering some kind of, cost risk challenge to parties on that space as well.
Yeah. Okay. I mean, it's almost, it's ancient history, but, tribunals were supposed to be places where people could bring their own cases and be helped through, presenting their own cases. They're now full of lawyers. So who knows? We may sort of
don't want to take the food from Claire's mouth here.
I was thinking about the barristers who all end up in tribunals now, but yeah, maybe we go back to that simpler system, as you say, to deal with some of the simpler cases, I hope. Claire, explain this point that's in the chat: recommendations for the length of probation going forward if we currently have 6 months.
Yeah, so conversation we're having with a number of employers is, they're looking at their probation period. So as I said before, the service requirement will reduce from 2 years to 6 months. But there is this slight oddity that doesn't really get referred to, which is that you effectively add on your statutory notice period, which would be a week. So you actually would gain your rights at roughly speaking 5 months and 3 weeks rather than at 6 months. So and often employers want to have the ability to extend a probation period. So these sort of classic probation periods that are 6 months won't really work going forwards, because actually by 6 months you will, if you haven't served your statutory notice a week before, then that those rights would be gained, and obviously at that point it's too late to do any kind of extension. So we've sort of had discussions. Some employers are moving to a flat 4 months. Some employers are talking about having a 3-month probationary period with the right to extend by up to 2 months. But really, the key thing is to ensure that managers are properly managing probation periods, that you've got a probationary policy in place, that you aren't getting to the day before the end of the probationary period and then going, oh, we better have a meeting, oh, let's extend, or you're perhaps even thinking about, oh, what did we do about probation? And it's a week or two later. So really properly managing probation, and actually for employees that will be beneficial. So really you ought to know how well you're doing in your new role before you get to the end of a 6-month probation period. And if you need to focus on different areas, then that ought to be being conveyed to you. So having a proper probationary review process in place will be to the benefit of both employers and employees.
Yeah. Again, sort of, just good, straightforward, good management. Are you actually monitoring and discussing performance during those first few months rather than leaving it to the end, which is what we know that does happen. So you'll see 4 and 5 months people are.
Just the key is just to make sure that you have had a proper review of whether this is if this has this recruitment been successful, is this person going to have a long-term future in the business, and making sure that is given proper consideration during that period. I think we've just had a question about whether probationary clauses has an effect on unfair dismissal rights, and actually they don't. You could have no probationary periods, or you could have a probationary period that says it's 9 months but dismiss somebody after 2. The way that the law will now work is different to how it was anticipated. So what the original proposals were, there would be a sort of an unfair dismissal light type process, so that in what was referred to as potentially going to be the first 9 months, you would have a different process. So really, the original proposal was that they would codify what you've just referred to, John, a proper process. But that hasn't happened. So what we've got is a sort of a 6-month all or nothing approach. So you've got no unfair dismissal rights in the ordinary sense. So ignore discrimination, whistleblowing, all of that type of thing, up until you've got that 6 months, noting what I've said a couple of times about the notice period. So if you did nothing ahead of that, you didn't manage probation very well, there wouldn't be a standalone claim around that. You still wouldn't have an unfair dismissal claim, but post 6 months, you would.
Okay, get it. Last opportunity for questions in the last couple of minutes. I mean, I think we had an event, a CRF event the other day in London on risk and risk management, and what's that got to do with HR? And I think it was a really interesting, really good event, in my opinion. And lots of interesting speakers. And we had a section of that on employee relations risk. And we should all say, I think, risk and opportunity, to be balanced about it. But I think it is coming up the agenda. I think boards are very interested. Boards of interest themselves in risk, in business risk, and they're very intrigued by the risks that are around people and people and culture, if you like. And yet their understanding of that is probably immature. So they are looking to HR functions to explain that and to, and to bring evidence and data, etc., to them of, what are they sensing in the environment? Are they picking up signals, early signals that things aren't going so well, for instance, and can we react to those early signals? So I think that was it was an interesting debate, and it's a sort of call to action to HR to say, are you actually out there monitoring in some ways? You might be monitoring the numbers of cases. Are they rising? If so, why? What sorts of cases, as Kevin was discussing, and that's a theme, and therefore what are we doing about that, and connecting that case management back to action, if you like, to action that you can take to preempt things. One thing we didn't mention early on when we were talking about the network is, although this session has been understandably all around the Employment Rights Act, that's what we set it up as, there are also changes happening in the EC regulations around European Works Councils, and we know that although many of our members are based in the UK, not all of them, but many of them, they can still be subject to European Works Council's regulations if they employ in the European countries. So we will do a little piece of research on that later in the year and have some expert input on what's changing there. The other thing I just want to say before we will probably wrap up is, with no more questions coming in, I bet you're getting lots of opportunity to ask these questions to your advisors locally, which is good. But the other thing is, and it has been referenced along the way, a piece of research we're going to do about networks and how people operate in networks, be they social networks or otherwise, and how impacts that has on the employment, the workplace, if you like. And Kevin mentioned in amongst that the impact of AI, and we have heard from our members how they are overwhelmed by some of these very complicated, long cases that are generated with the help of AI, if you like. So look out for those two things. But I'm going to stop us there. It's 2 minutes to the hour. Thank you all for your attention. Thank you for listening. But super thank you to Kevin and Claire for our inputs today, which have been super helpful. So thank you for that. We will send you more details on the network, and we'll send you a link to the research, and you've got the link to Eversheds tracker, which is all very helpful. If you want to find out more about what we're doing in the network, Mel has put her details in there too, and should be pleased to share more detail. So thank you all for that, and we'll wrap up at that point and hope to see you all again soon. Thank you.
Thanks, everyone.
Well, bye.